Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today for what is called an arraignment. The arraignment basically is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your most serious type of criminal offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, the case, again, that you have in this court is a misdemeanor case. Now, your felony cases are divided into five categories. We start at the top and work our way on down to the bottom. You have a capital murder, first degree felony, second degree felony, third degree felony, and a state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, a fine that does not exceed $10,000. If you're convicted of a third degree felony, range of punishment minimum 2 years to a maximum of 10 years, a fine that does not exceed $10,000. If you're convicted of a second degree felony, range of punishment minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If you're convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if you're convicted of a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. And as I mentioned earlier, your case is a misdemeanor case, so you don't have to worry about that. Misdemeanors are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. You have a Class A misdemeanor, then you have Class B, and a Class C misdemeanor. Class C misdemeanors are cases that are normally, they originate either at the JP court, which is the justice court, or the municipal court, which is the city court. And if a person appealed that case, then the case comes to this court. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. The fine usually does not exceed $500. However, if a person fails to pay the fine or court costs, then it could be converted to community service. If it failed to perform the community service, then a court can issue what is called a capious pro fine. And that simply means that there's a warrant for your arrest for you to sit out the fine. In essence, you can serve out the fine by serving time in jail. Now, the Class B misdemeanor, the range of punishment minimum 0 days to maximum 180 days. You could be given a fine for anywhere from $0 to $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, range of punishment 0 days to maximum 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation. First type of probation is normally referred to as regular probation, which is adjudicated probation. With adjudicated probation, it does result in a conviction in your record. However, there's something that is called judicial clemency, whereby the court can set aside the conviction and you will not have this conviction on your record. Now, in order for that to happen, you have to successfully complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged from the probation. And then the court can set aside the conviction. Now, if you try to get a license with CPS, then if you if you get a subsequent conviction, meaning that if you get another conviction later on, then this case that you got judicial clemency on can be revived, resurrected, or brought back up and used against you. And if you try to get a license with CPS, they could either deny giving you a license, or if you have a license, they could either suspend or revoke that license. Now, the other type of probation is called deferred probation or unadjudicated probation. With that type of probation, it does not result in a conviction on your record. And if you successfully complete the probation, you may qualify for what is called a non-disclosure. And what a non-disclosure is, it just basically means that the court cannot disclose the fact that you are on deferred adjudication to the general public. However, the government can have access to that conviction. Now, as a defendant in a criminal case, as I mentioned earlier, you have rights. One of the rights that you have a right to have an attorney. And regarding your right to have an attorney, you should have some paperwork on a clipboard before you. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. And on that document, it states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, if you want to hire an attorney, then your case will be reset to give you time to hire your attorney. Reset means you'll be given another court date to give you time to hire your attorney. If you want an attorney and do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Now, before you can do that, you have to first fill out a financial questionnaire. The financial questionnaire is the third document on the clipboard. It is titled Jefferson County Affidavit of Interest. You have to fill out that document so that the court can determine whether or not you qualify for a court-appointed attorney. Now, if you want to represent yourself, that is, if you want to waive your right to have an attorney or give up your right to have an attorney, and if you want to represent yourself, you would have to first fill out a written waiver of your right to an attorney. Now, the written waiver is the second document on the tablet, and it is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You would have to read and fill out that document. And once you read and fill out that document, then you'll be able to represent yourself. And by representing yourself, you will have an opportunity, if you desire, to talk to the prosecutor about your case to see whether or not you can work out a settlement or a plea bargain on the case to settle your case. Now, you should be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, that is, if you decide you wanted to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, that first document, Judge's Explanation of Rights to Defendants Without an Attorney, in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you will put your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you'll put your initials on the second line to the left and the name of the attorney on that line to the right. If you want to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, give up your right to an attorney, and represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the bottom of the document that is titled Defendant, and you will date it today's date, January 2nd of 2024. Now, for those of you who will be waiving your right to an attorney or giving up your right to an attorney and representing yourself, you would have to read and sign the second document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And it reads as follows: I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily, which means that nobody is forcing you to do it. You're doing it of your own free will. And intelligently made means that you know what you are doing. Furthermore, I have been advised the second day of January 2024 by the County Court at Law No. 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed to represent me. I further waive, which means give up, my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, January 2nd of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. Now, when the young people are sitting in that area over there, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to the evidence, listen to the arguments, they will deliberate, and they will decide to find you either not guilty or guilty. Now, you can waive, which means give up. You can waive or give up your right to have a trial by jury as well. And if you waive or give up your right to have a trial by jury, then your case will come before the court in one of 3 ways. One way it will come before the court is by way of a bench trial. A bench trial is a trial by judge only. You do not have a jury. It will be the judge. The judge will listen to the evidence, the arguments, and the judge will decide whether or not to find you not guilty or guilty. Another way that your case can come before the judge is by way of an agreed, well, by way of an unagreed plea bargain. Let's say you and the state, or you and your attorney, and the state has been talking to see if they can negotiate an agreement to settle the case. And if you are able to work out an agreement, we call that an agreed plea bargain agreement. If you're unable to work out the agreement, we call that an unagreed plea bargain agreement. If you are not able to work out your case, to settle your case with the state or the prosecutors, and we have 2 in the court sitting at the table before you, then your case will come before the court by way of an unagreed plea bargain if you still desire to settle your case. And then if it comes before the judge by way of an unagreed plea bargain, the judge can either accept or reject that. The judge could say, well, if it comes before the judge by way of an unagreed plea bargain, then the judge will decide what the punishment will be in your case. And if whatever the judge decides, it will be within the punishment range. Okay. Now, if you have if you're in the state or your attorney in the state have been able to work out a plea bargain agreement, we call that a plea bargain agreement, an agreed plea bargain. Then it comes before the judge, and the judge can either accept or reject your plea bargain. Now, if the judge rejects your plea bargain agreement, then you have a right to withdraw or take back your plea. For example, let's say you're in the state has worked out a plea bargain agreement, and the agreement is for you to serve, say, 10 days in jail. And the judge says, well, I'm not going to follow that plea bargain agreement. Now, if the judge does not follow the plea bargain agreement, you can tell the judge, well, judge, I withdraw or I take back my plea. You have a right to do that if the judge does not follow the agreed plea bargain agreement. Now, if the judge does follow the agreed plea bargain agreement, and within 30 days you decide that you would like to appeal your case, then you have to get permission from the judge to appeal your case. And what I mean by appeal is you would you think that you've been wrongfully convicted, or you think that the court has committed an error by convicting you, and you would like to have a higher court to review your case, then that's what we call an appeal. That higher court is located actually right above us on the third floor. It's called the Ninth Court of Appeals. Now, they will review your case. Now, they could either grant or deny your appeal. If they grant your appeal, they could just simply find you not guilty, or they could send the case back down to this court or to this court to give you a whole new trial. Or if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals, which is located in Austin, Texas. It is the highest criminal court in the state of Texas. You would have to file what is called a pro se petition for discretionary review. What that means is this: pro se means you'll be representing yourself. You'll be asking the Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted, whether or not this court wrongfully convicted you, or this court committed error by convicting you. Now, they can do one or two things. They can either grant or deny your pro se petition. If they grant your pro se petition and they review it, they can just simply find you not guilty, or they can send the case back to the Ninth Court of Appeals, or they can send it back down to this court, or to this court to give you a whole new trial. Or now, the other thing is, if they deny your pro se petition, if they deny your pro se petition for discretionary review, at that point, your conviction will stand. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. The chair that has the microphone in front of it, we call that the witness stand. And witnesses, they'll come to court. They can either testify for you or against you. If you represent yourself, you can ask the witness, your attorney can ask the witness questions. We either call it direct examination or cross-examination. Now, you also have a right to waive or give up your right to have a trial by jury. And what that means is that you will not be having, you can waive or give up your right to have witnesses to come to court. And what that means is you will not be calling any witnesses in your case. However, it does not mean that the state will not be calling witnesses in the case, because they will be calling witnesses in the case. Now, you also have a right against a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your case. State of Texas, the government cannot force you to testify in your case if you invoke your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. And if you waive or give up your right against self-incrimination, then you will be testifying in your case. You also have a right to have what is called discovery. Discovery is you have a right to see the evidence that the state has against you, or the evidence that the state will be using against you. You have a right to see the document, to have access to the documents, witness statements, lab reports, your statement. You have a right to have access to the videos or audio recording or any type of instruments that the state will be using in your case. You also have a right to waive or give up your right to have discovery. And by doing so, you will not be having access to the evidence that the state will be using against you in your case. Now, as a defendant in a criminal case, or as a defendant in the case that you have in this court, obviously, you're here, you're out on bond, you have been arrested, placed in jail, and then you were released on bond. You was either released on a surety bond, which means that you paid a bond with a percentage of the bond to get out of jail, a cash bond, which means that you paid the full amount of the bond to get out of jail, or you were released on a PR or personal recognizance bond, which means that you were released under your own personal recognizance with a promise to appear here in court. Now, every day that you spent in jail, that jail time can be used as credit towards your offense. So, for example, let's say you spent 5 days in jail, and let's say you and the state has worked out a plea bargaining agreement for you to serve 5 days in jail. That simply means that you will not have to serve any more time in jail. Why? Because you will be given credit for the time that you've already spent in jail. Now, the time that you spent in jail also can be used as credit toward your fine and court costs. So, for example, every day that you spend in jail, you get credited $100 per day. So, if you spend 5 days in jail, that's $500 that can be used toward your fine and court costs. So, for example, if the state is offering for you to pay a fine and court cost of $500, you spend 5 days in jail. That simply means you would not have to pay the $500. Why? Because the time that you spent in jail has already paid it off. Now, if the state is offering that you serve 7 days in jail and you spend 5 days in jail, that only means that you have to pay 2 days. You have to spend 2 days in jail off days, charging you a fine of fine and court costs of $700, and you spend 5 days in jail, then that means you'd have to pay $200. Now, the $200 fine and court costs will be paid on the day that you enter your plea. Now, if you cannot pay it on the day that you enter your plea, we can put you on what is called a payment plan, which means you'll pay it off in monthly installments. Now, if you're unable to pay it off in monthly installments, then we can convert your fine and court costs to community service. And if we convert it to community service, you'll be given $12.50 that will go toward your fine and court costs for every 1 hour of community service that you perform. So for example, if you perform 8 hours of community service, that's $100 that will go toward your fine and court costs. Now, Jefferson County has a program that is called pretrial diversion. With the pretrial diversion program, actually it's a program where if you qualify, you get into the program, they'll dismiss your case. Okay. And you can get it removed from your record or expunged from your record. And in order to qualify, it has to be your first time getting in trouble. It cannot be a case involving resisting arrest or unlawfully carrying a weapon. And you have to have an attorney to assist you to get into the program. And again, if you get into the program, case is dismissed. And if you complete the program, you can get it expunged, which means erased, wiped off, or deleted from your criminal record. Jefferson County also has another program that is called Veterans Court. If you are a veteran of any one of the branches of the United States military, that program is also part of the pretrial diversion program, which means that if you qualify, you get into the program, you complete the program, your case will be dismissed, and you can get it a non-disclosure for that, which means that we cannot disclose to the general public that you had this case. Okay. Now, this court has a program that is called the pretrial, that is called Community Safety Initiatives. That's a program. The Community Safety Initiative is a program that is also referred to as the CSI program. That's a program that started in March of 2017, which is going on 7 years this year. That program is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so in order to address the issue of recidivism, we have the CSI program, which is designed to make Jefferson County a safer place for all of us to raise our children, to live safely in the public, raise families, go to church, and do, just have a safer community. With that program, we have a partnership with various agencies. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop Center is our local mental health center. And we have some folks from Spindletop. They're going to come to you in a few minutes and tell you more about that program. But basically, what the program does, they'll be able to do a private interview either here in our jury room, or they can have a private interview on the telephone or at their facilities, whichever is convenient. They can develop or do an assessment and develop a treatment plan, either for outpatient or inpatient treatment. Now, you do not have to be incompetent and insane to participate in the program. You could just simply suffer from depression, anxiety, or any host of other mental illnesses. The other thing is Spindletop also has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. That is a alcohol and drug recovery program. Ozark, now our local alcohol council also has a program that is called Ozark. Ozark stands for Outreach, Screening, and Referral. With that program, both of those programs are designed to address issues of alcoholism or drug abuse. They will be able to do a screening, do an assessment, and develop a treatment plan, either outpatient or inpatient, to meet your issues that you may have with either alcohol or drugs. Now, we also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas that you're trained in, that you select, then they will assist you at getting a job in the areas that you're trained in. If you have not graduated from high school and you like to get your GED, then CICE also has a GED program where you can get your graduate equivalency diploma. And all of those programs that I just mentioned are free. It does not cost you anything. Only thing it costs you is just some time. And in this court, we like to say that we do not just give time, we take out time. And we believe that we don't just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people, then we can make Jefferson County a better place for all of us to live, work, go to school, and raise our children. That program, I like to say, is that we do not, in County Code Law number 2, as I mentioned earlier, we do not just arrest the problem, we address the problem. Here, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in the lives of the individuals that come before this court, we're going to make a difference in their homes. If we're able to make a difference in their home, then we'll make a difference in the community, because what comes out of the home go into the community. And so if you're interested in any one of these programs, just let us know. And we'll be happy to direct you to the people who can assist you at getting into any one of these programs. Now, as I mentioned earlier, we have some folks from Spindletop. We have Deputy Hinton and Chris. They're going to come now and tell you, give you some information or some vital information on the program that Spindletop has to offer.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state, commissioned here with the sheriff's department. This is my coworker here, Chris. Now, Chris is a qualified mental health professional. The reason we are both here this morning is because the judge cares about every single person who comes before him. The judge has found, as those who have legal issues commonly have, mental health needs such as use disorders, or sometimes just a lack of community resources to help you to participate.
The reason more health needs, like the judge says, anxiety, depression, things that happen on a day-to-day basis that we all deal with. Being in the court system doesn't necessarily make it easy. Also, I am pretty hoarse today, so I apologize. But outside of that, substance use could be alcohol, tobacco. There's a lot of really great community resources in this area or in Texas in general that are well funded, but they're not well advertised. And sometimes getting set up with them can be that like jumping through the hoops. And that's kind of where we come in. That's what it kind of means by treatment plans, just getting you set up with resources, getting you connected to anything you may need to connect to, or just getting you someone to talk to.
So maybe this is your first time to be here. Maybe it's your 10th time to be here. There's still hope. In fact, what we're offering you today has the ability to change your life, but we're going to need something from you. Now, Chris passed out a document to you early, and she's going to explain to you about that document and how you can use that to actually share that need with us very privately.
So the document I handed to you guys functions as the baseline of the consent form. All you are consenting to on that is me contacting you once. The only person who will reach out to you is me. And if you don't respond, I will not. It's not a robocall situation. I'm not going to keep blowing up your phone, I promise. But if you work with me, I'll work as hard for you as you do for yourself. And I know you all showed up here the day after New Year's. You obviously work hard for yourselves. So I will match your effort. If you tell me there's something you need, I will do my best to find it. Doesn't matter if you're from this area, because we know A lot of people come to come before Jefferson County that are not necessarily from Jefferson County. We know that sometimes they're from the other side of Texas, sometimes Louisiana. It doesn't matter where you're from. If there's something you need, I will do my best to find it. And it doesn't matter if you're here for yourself, or you're here as support, or you need information for somebody else. It matters is that you're here, and that's why we handed it out to everybody who came in. Because the whole point is that you guys are here in this courtroom right now. So if we're gonna be here, it's using the moment. It doesn't matter if you're here as a defendant, it's just tell us what you need.
Also, I have this flyer that I want to put in everyone's hands before you leave here today. On the back, it tells you some of the advantages of actually participating, but also on the front has a 1-800 number should you ever find yourself in an unsafe place. You can call that number and get help immediately.
So what's interesting about that is the first resource we will need, because that 1-800 number is active almost statewide, which is why I say again, doesn't matter if you're from this area. I usually tell people that if you can call them at 7 a.m. on Christmas morning, they'll pick up. We're a little bit past that now. We kind of skipped over Christmas, but you can call them anytime and they will pick up, and they will either talk to you in that moment or get you set up with the closest available resource at the given time.
Now, just shortly, the court's going to go into recess. When it does, we'll be able to come out here and visit with you and answer any questions you have. We'll pick up those documents from you, and I'll also give this.
On the bottom of that sheet as well, there is an option to speak privately. That just means going back with me into the jury and panel room for a little bit. If you have something you would like to talk about today and you select that, that's all that's going to happen. If you want me to, so the thing is, if you don't select that, I will reach out to you tomorrow by whatever means of communication you would like to, okay? So thank you guys for your time. We'll be out there soon.
Okay.
Thank you, Your Honor.
Thank you, Deputy Hinton and Chris. Now, ladies and gentlemen, the paperwork that you have on the clipboards, if you need any help with filling out that paperwork, then we have someone from our court personnel who will be happy to assist you in filling out that paperwork. Now, the document that is titled Jefferson County Affidavit of Indigence, make sure that that document, the first page, is completely filled out. Now, if, for example, when they ask for financial information, if you do not, if that doesn't apply to you, just put a 0. For example, if that's if you receive any governmental benefits on that document at the bottom, if you're not, it's just 0. So don't leave anything blank. And then at the bottom on both sides, you're going to total. On the second page, you're going to fill out the top portion and the middle portion. And then the bottom portion, I will fill that out. You don't have to worry about the third page. That page is just for the court to fill out, okay? Now, as I mentioned earlier, we have someone from our court who will be happy to assist you with filling out that paperwork. We're going to pick up the paperwork from you. It's going to take us a little time to pick up the paperwork and evaluate, make sure that everything is filled out properly. And then once that's done, then we're going to ask that you will come before the bench or before right in front of me. We call this area bench. And we're going to call you up one at a time to go over your paperwork. Okay. Now, as I mentioned, it's going to take a little time. If you need to use the restroom, there are 2 restrooms right outside in the hallway. The men's restroom is right next door in front of County Court at Law Number 3. And the women's restroom is on the opposite side of the hall from County Court at Law Number 3 in front of the 172nd District Court. Now, you can leave the courtroom to use the restrooms in the hall. That's out in the hallway. Now, do not leave the courthouse, because if you leave the courthouse and if you call your name, you're not here, a warrant can be issued. Well, your bond can be forfeited and a warrant can be issued for your arrest. So at this time, the court is going to go into recess. And the court, once the court is going into recess, then we'll go over that paperwork.